Ladies and gentlemen, we'll be starting in 3 minutes. We will be starting in 1 minute. Good afternoon and welcome to the National Association for Court Management webinar, sponsored and hosted by the Professional Background Screening Association and the Consumer Data Industry Association, Best Practices for Upgrading Court Records. My name is Charleston Carter, and I'm introducing our co-presenters, Jose Dimas with Professional Background Screening Association and Jay Harris with the Consumer Data Industry Association. I am the trial court administrator for the Superior Court of North Carolina, 26th Judicial District in Mecklenburg County, and I serve on the NACM's Board of Directors. Before we get started, I would like to go over a few items so you'll know how to participate in today's event. This presentation will be approximately 60 minutes long, and we are recording today's webinar. The webinar will be available for members on the NACM's website. If you are joining the webinar today on your computer, you can submit questions to today's presenters throughout the presentation by typing your question into the question pane of the attendees control panel. Mr. Dimas and Mr. Harris will address your questions during the Q&A session at the end of the presentation. Industry experts Jose Dimas and Jay Harris will explain how your court can develop consistent and reliable access to court records and present technology solutions designed to meet the needs of all users and reduce barriers to access. It is my pleasure to introduce our presenters. Jose Demas is in the Government Relations Director of the Public Records Access for the Professional Background Screen Association. Prior to coming to the PBSA, he was a Government Relations Associate for the National Center for State Courts. He has an extensive experience in state courts and government relations, having worked on the Capitol Hill, federal government, and for the nonprofit sector. Mr. Demas has a bachelor's degree from the University of Texas at Austin and a master's degree in public policy from Bayers University. Jay Harris is outside counsel of the Consumer Data Industry Association. He has extensive experience as a general counsel and business leader for leading consumers, reporting agencies, and data repositories, and serve as a government affairs chair for the Professional Background Screening Association. A member of the Virginia State Bar and is a graduate of the Johns Hopkins University and the Antonin Scalia School of Law. Thank you for hosting us today, Mr. Demas and Mr. Harris. To you.
Well, and thank you for having us. We appreciate it. This is Jay Harris, and we're delighted to be here today to talk a little bit about the uses of criminal history records from our members who are regular users of court as well as corrections and other public records used predominantly in background screening and monitoring for employers, landlords, and contractors around the country. So what we want to cover today here on our slides, introducing a little bit both organizations, Jose and myself, and talk about a co-produced software specification, a technical spec that we call PASS, or the Public Access Software Specification for query and response to inquiries about criminal history case information and identifying information, so that our members can accurately aggregate and report criminal history information around the country and indeed around the world using US court information. We'll talk about the current context, kind of where we are today, some of the user needs and expectations, as well as some of the regulatory expectations that are increasing demands on our members and on court sources for prompt, accurate criminal history information. Then talk about some of the constraints that we run into with courts that we don't run into with other sources, and talk a little bit about some suggestions we have built around the PASS document in order to address those concerns. So let's dig into it. And to introduce both organizations, Consumer Data Industry Association represents providers of credit and consumer reporting data, including public records, such as criminal history, conviction information, licensure information, and sanctions from public sources, as well as from private furnisher sources across the US and indeed across the globe. Also, Professional Background Screening Association represents employment, tenant, and other kinds of background screening providers working around the globe as well. We've been through introductions. I won't spend a lot of time on this, only to say that having served on the National Center of State Courts, NODS, National Open Data Standards Advisory Council, I'm familiar with many of the challenges that courts face, system constraints, budget constraints, and so forth, in promptly responding with sufficient identifying information to queries that our members have. So that's a little bit about me. Jose, why don't I turn it over to you?
Jay, can you hear me?
Loud and clear. Take it away.
Great. Fantastic. Thank you. Thank you, Jay, and thank you, Mr. Carter, and thanks to your members for listening to us today. Letting us present to your group. Hope everybody is having a good week and staying safe. As Mr. Carter mentioned, a good part of my background was working on behalf of the state courts, I was employed at the National Center for State Courts for 16 years, doing primarily government relations work with the administration in DC. I know I attended at least 2 NACM meetings in my time at the NCSC, always big meetings, a lot of fun, great events, great locations. I think one of the ones that I remember vividly was New Orleans, which was a great meeting. And you always seem to have very good meetings and challenging sessions. Some great people I met there, always helpful, really help with our issues, especially with legislators back home. Former colleague at the National Center, Kent Pankey, on your board, who is now with the Virginia Supreme Court. I'm not sure if Kent's listening, but I hope he's doing well. Hi, Kent, if you are listening. Also, one of a member from NACM that I learned a lot from was Bob Wessels, former NACM president from Harris County, really knowledgeable about technology and problem-solving courts, and I always went to him for any kind of questions that I had on those lines. Our plan when I started this year was to join you, go to a meeting, go to a mid-year meeting or an annual meeting for NACM. Of course, with the pandemic, that's been put on hold, but I do hope to join you maybe next year or the year after that, so you can learn more about our organization and our members. My issues that I handled for the National Center had to do a lot with court administration and devoting resources to the courts, because it seems like your issues always had to do with budgets. Some of the issues that I worked for included fighting unfunded mandates, getting funding for drug courts, getting funding for court security improvements, and even maintaining the funding that courts have now. For example, the State Justice Institute, SJI, who give a lot of their funding, most of it, to the state courts. Not only getting funding, but also making courts eligible to apply for grants. Recurring theme that I encountered was we saw a lot of funding going to governors and state executive branch. We always make the case that courts had equal needs to protect their buildings, for example, in the court security area and their personnel. But the Department of Homeland Security really just gave a small portion of funding to the state courts. I think we had a survey once and came out to 5% of all the money they gave out since they were established. Most went to police and fire department. It was making courts eligible to even apply for some of these grant funding programs all throughout that were established. In thinking about budgets, we wanted to offer you these past standards, which are best practices, free of charge, when and if you're ready to improve or upgrade your court record systems. We're ready to talk more in depth about these standards and meet you virtually now or in person after we are over this COVID crisis. Get the next slide, please, Jay. Again, as Jay mentioned about PBSA, we were started in 2003 by a small group of members, so regulation of the industry. We have over 900 members. We're a global organization with members in Europe, Canada, and Asia. We look to promote excellence in the background screening profession, and we invite you to go to our website to learn more about the profession and some of our activities. You can see the hyperlink right there. Thank you. A little bit of a busy slide, but I just wanted you to concentrate on 3 elements about background screening: the basics, the process, and our accreditation process. The basics: what is a background check? What constitutes a background check, and how do we do those? We rely on court data to complete background checks for intended purposes. We're the folks that go to your courthouses, the court reading rooms, and research individuals job candidates looking for employment. We can tell you, based on survey data, that for the past 4 years, 90% of employees do background checks on prospective employees, and the vast majority of those include a search of one's criminal record. But many outside courts, our members don't realize is that when a candidate authorizes the employer to do the background check, it is not a simple one-stop shop. Our members need to access court data from throughout the country, as well as for things like driving history, education, and employment. In the process, that's the middle block there. We obey by all the federal, all various laws, state and federal, that we have to follow, and we have responsibilities to the consumer. This whole process is governed by federal law and has some specific requirements for disclosure and authorization, as well as reinvestigation if the job candidate disputes the accuracy and completeness of the information in the background check. Accreditation. This is assigned to you and anybody that hires us, that the information we collect is safeguarded by our standards, which includes audits and several other checks we perform on our members. Again, we welcome anybody to view these resources on our website and ask me or Jay any questions about these elements. Next slide, please. Wanted to talk a little bit about remote access, especially during COVID. When this COVID crisis first broke, we were shut out of the courts for legitimate reasons. You court officials, court leaders didn't want the public, including the courthouse. We also did not want to be infected or exposed to infection, and we wanted to do as much remote work as possible. So I approached leadership of COSCA primarily, Joe Baxter, the State Court Administrator of Rhode Island, and David Slayton, the State Court Administrator of Texas. Joe is the chair or co-chair of the CCJ COSCA, Conference of Chief Justices, Conference of State Court Administrators, Court Management Committee, which deals in all sorts of technology and all sorts of court operational issues. And they were in charge of this RRT, the Rapid Response Team of CCJ and COSCA. And they released a number of papers. This had to do with more technology, but there were others having to do with remote hearings, dealing with children and family cases during the pandemic, and other such issues that were pressing when the crisis was evolving. When we did searches in the pandemic, we started getting big backups in terms of numbers we had to perform because we couldn't get in. To give you an example, we saw some instances where nurses were kind of in their 50s, getting ready to retire, and they took early retirement or resigned from jobs. They were at an older age, and they were afraid about the consequences of being exposed to the virus. So they resigned, and they had to be replaced. And we had to do background checks on those individuals. And as you can imagine, that poses a threat to hospitals when they're not fully staffed to handle any kind of emergencies having to do with COVID personnel. The same thing was happening with warehouse workers, grocery employees, truck drivers, and those kinds of essential personnel that were needed when the pandemic was raging. So I asked Joe, and I sort of gave him these points, and they responded with this paper on promoting this. And we were really happy to see that it mentioned some of the things that we were saying. In my fourth bullet point, I have a quote there about how some of these technology solutions have been tested and proven for years. This pandemic expedited the use of those technologies. The next bullet mentions us as researchers and as one of the stakeholders that depend on court records and the need to access those remotely. And finally, the last bullet point there just mentions that try to avoid requiring users to pay additional costs for using technology or remote, because the public needs to get those, and that's something that we welcome. Right below that last point, there's a link to the paper if you want to pull it up, and that the right part of the slide is just the first page, but it's available online. So with that, I will turn it over to Jay, who will go into more specificity of the past standards.
Thanks, Jose. We talked about CDIA already a little bit. Let's dig in here to the standards themselves. So the public access software specifications that CDIA and PBSA co-developed are really designed to promote timeliness, accuracy, and efficiency in the search process for criminal history records. And in particular, what we're trying to do are specify the identifiers that are needed about individuals as well as case information based on generally available information, existing variables that are built into current commercial off-the-shelf court access systems. But these are key case identifiers and personal identifiers needed for identification of records that have been previously reported and may subsequently be expunged, or new information, conviction, supplementary information subsequent to an arrest, so that we can timely identify at scale the current status and the affected consumers involved in a criminal records matter and report it timely. Important to us and addressed by the past document is search match logic, so that there's clear understanding about what we should expect to come back where a new system for public access is introduced. Sometimes, in our experience, we've lost identifiers or we have lost in the match logic variety and a level of detail for things like wildcard searches or common name information, because the match logic underlying the access has changed, sometimes without notice to the user community in background screening and the general public. So it's important to know that the search match logic, what that is, and we have some specific suggestions here for privacy preserving verification. A match flag of yes or no in the circumstance where a court or other jurisdiction wants to limit public disclosure of certain identifying information, but is in a position to verify if that James Smith with this particular full date of birth as provided by a record user, a CDIA member, a PBSA member, if that individual with that identifying information is the same one as they have on file. So in other words, it's not necessary in every case to reveal a full date of birth and other identifying information if the jurisdiction can simply verify that the information pushed to them by the user matches against what's in the court record. That is as one possible approach to balance between existing policy as well as the growing need on the outside in the regulatory environment for clear, accurate identification of the consumer and the current state of their record. And then finally, search scope. The past document also talks about making sure that it's clear in public access parameters which records are covered. Have there been an introduction of a new system that with the new system, several years worth of records previously available are no longer searchable? Having some notice about the scope of the search is important so that we can make sure that available records have been found and that records previously reported are accurate. Similarly, the length of time. In some cases, we find that a search may not go back as far as it used to, and so we may need to get clear detail from the disclosing jurisdiction about how far back the search goes. These are some of the areas addressed by the past document as a way to make sure that the user understands quickly and accurately what is returned in a particular query, so they can conduct additional queries if they need to get a full and accurate information, particularly for individuals with common names. The other point here is that the PASS document addresses both query access as well as bulk record access information. We think by standardizing both the call and response as well as the individual variables in more jurisdictions, we can drive some more efficiency in the court process without significant additional cost, and also maintain the increasing scale and precision that is demanded both by the market and by applicable regulation under the Fair Credit Reporting Act. So what's driving this? We have significant expertise in the industry. PBSA and CDIA members are some of the most sophisticated global consumer data records organizations. They have a strong understanding of the use case and the need for this information, whether it's for an initial background check or for monitoring of a driver fleet or some other purpose. And we're familiar with working with tens of thousands of types of sources, both private and public, not just in the US, but around the world. So by leveraging this knowledge about how to standardize identifiers and sources and variable definitions, we hope to improve the efficiency of verifications that happen today and drive greater search accuracy from the court records that we rely on. By meeting greater expectations for turnaround times and regulatory accuracy, we think we can improve the relationship that users have, some of the largest and most sophisticated users have with the court community. And that's why we're here today. So the PASS document here is available in the public. It's not password protected. You can click here. We'll make available this information. It's on the PBSA website. The slides will be available after the presentation, so you can see the details in the PASS document and ask Jose and I, as representatives to the industry group that has developed this document, any questions you may have about how this would apply at your court system. So let's talk a little bit about the current context, as I promised. First of all, as it relates to the demand for criminal history kept by courts, departments of corrections, police, and other sources, industry represented by PBSA and CDIA are developing solutions that meet growing demands. First of all, I think it's critical to remember that PBSA and CDIA members build reliable public safety products that are unavailable elsewhere. By combining from thousands of counties, information available from disparate systems and disparate record types, the industry is able to aggregate and deliver accurate information around the globe on, in some cases, an instant basis or near instant basis, depending on the constraints of the source file and the needs of the user. And these sophisticated industry processes, we would argue, have some learnings that can be useful as courts and departments of corrections adjust their public access rules and technology. Secondly, the background screening reports are widely used, are relied on. Those provided by the private sector are important as an integrated source of criminal, credit, licensure, education, driver records, and so forth for many, many public safety uses, both for initial checks as well as ongoing monitoring around the world. Indeed, the value of the reports provided by the private sector are such that in Colorado and other states, private sector background checks are used to correct and update missing disposition information used in FBI fingerprint checks. And we see an increasing use of these accurate private sector checks to make sure consumers have the best possible information and employers have the best possible information in evaluating fitness for a particular job. And so finally, as well, the utility goes not simply to the delivery compared to other government fingerprint checks, but also to the fact that these are widely used in practice in dozens of background screening software suites that are used to deliver accurate information timely, but also provide appeal rights to consumers who are concerned about the accuracy or the currency of the information that's in the report. That's a little bit about what the industry is doing in response to demands. The other constraint here that's important to remember are the regulatory constraints. To a greater degree than our sources, CDIA and PBSA members are on the hook for regulatory exposure on how we report information. So our needs for timely, accurate information from court and correction sources continues, and indeed is even greater than it was a decade ago in terms of the expectations for timely turnaround and the level of detail needed in the record. Federal Trade Commission has provided some guidance that we meet and exceed. We describe it a little bit here as well. Jose mentioned the PBSA certification, something that hundreds of background screening organizations rely on to make sure they are promptly delivering accurate information. These voluntary standards that exceed applicable law also are driving increasing demand for prompt, accurate information from court sources, whether it's available by remote electronic access or by manual access of some sort. So the high volume user needs that PBSA and CDIA members represent are increasing our demands on criminal history organizations, including the courts, but not limited to the courts, as we run hundreds of millions of criminal screening and monitoring transactions for public safety every year. This criminal history information we get from courts and departments of correction and police are a key component of a comprehensive, timely public record check. We are finding that as the economy rebounds, even with the constraints in court access due to COVID, the demand from the private sector for prompt turnarounds on background checks for hiring and for landlord-tenant uses is stronger than ever. So this growing demand makes remote electronic access to court records preferable to manual efforts. The past document attempts to advance this agenda. And so what's needed? We need personal identifiers, case detail in order to comply with these state law obligations. The trend in which date of birth and other PII information is either reduced or removed altogether from the public record delays and creates matching challenges that weren't there a decade ago. So let's talk about some of the examples here at the source agencies that are impacting industry use. And we have a few categories with some general examples of each. One are changes to access software at the courts or other public sources, public agency sources that actually removes key identifiers. So this may be removing essential case information without notice, older records that were available as states have moved from a county disclosure format to a statewide disclosure format. For example, over a couple decades worth of criminal history records previously available have gone missing with no notice to the user. We suggest that the better approach where there is a change is to inform and make folks aware of lost records or removed records as a system is moved from a legacy system to a newer one. And simply moving to a new system does not suggest at all that older criminal history records would go missing all of a sudden. But certainly the lack of notice creates issues. Similarly, and this is fairly common, where a full date of birth information is removed and substituted for only a year of birth or some other partial birth identifying information. We see and have several state examples of this. Many of you, may be on the phone already and familiar with this. I'm not going to mention any specifics, but the result of removing full date of birth information is to increase the demand on court clerks for accurate verification, particularly of consumers with common names. And so if this is removed as a across county by county across the state in one case, or in other cases where a statewide source is removed altogether. And so accurate verification has to then follow to the county by county level in order to accurately figure out which James Johnson we're talking about. The result has been in case after case that local court clerks are solving more of these issues, confirming with a manual verification where the full date of birth identifier has gone away. It doesn't need to be this way. There's several models that work that offer limited access to full identifying information, including full date of birth information, that work in several jurisdictions around the country. But I think it's not a surprise, but it is a problem that needs to be solved and anticipated where there's a change in policy that limits and reduces access to full date of birth identifying information. In that case, we need to anticipate the workload that this imposes on local clerks to resolve common name matches. It's avoidable. There are models that work, and that's something we'd certainly be interested in discussing with you, Jose and I, if your jurisdiction is one of those that's considering that kind of policy or access technology change. Similarly, we also find that disposition variables may be lost as there is a quote upgrade in the software, and the result where information about the disposition of the case, particularly a complex charge situation in a case where the resolution of each of the charges is unclear under the new disclosure model. This delays the turnaround times that are required to accurately verify the case detail. It's avoidable, and one of the reasons we're here today is to discuss how we can engage earlier in the process to make sure that any change in policy or access technology does not lose these key identifiers in the dispositions as well as the personal identifiers. And then finally, a situation where the search logic has changed. This too creates issues where wildcard searches that used to be available are no longer there. It will slow the time it takes for us to complete each individual search, where we have to run more searches on one individual in order to clear him or her. Secondly, we also see that identifiers, as those are restricted or removed, clearly the general trend has been to reduce these identifiers. As we mentioned, best practices do exist where there are registered users, systems that let remote automated access with sufficient PII and adequate case detail for registered users. These kinds of models we support, and we think, frankly, they can strike a better balance between privacy concerns and at the same time the needs of court administration, where high volume users need this information regularly in order to adequately identify an individual and the case information accompanying them. And then third, on the access software limitations, this too, and this is again where we're talking about no change in the access software, but a burden on the court clerk simply because of constraints on legacy software. Jose mentioned the 3 Bs of budget, budget, budget. We understand that well. We think there are low cost and no cost solutions that work, that can remove some of the access rationing that we experience in some courts today, where the software is not calibrated to meet the demand or the detail that is needed for criminal history checks in that jurisdiction. And one thing in particular we've been spending some time on over the last several months have been in a couple states with new broad expungement laws, where we are working to make sure that these do not substantially increase the burden on court clerks who have to check and see if information they provided previously, if that information now has been expunged, or if part of the record, but not all of the record, is subject to the expungement. We want to make sure that as much of that expungement administration can be accomplished in a way that's automated and with the minimal amount of clerk involvement. So that change, as that expands to more states in the years ahead, expungement administration, we think, will be important to get right. And making sure the software is properly configured is something that we are ready to help the courts with. And finally, I think the point I'd make here is just that access technology planning sometimes misses the established use cases. We talk fairly regularly with courts and departments of corrections who aren't aware of the volume and the need for detail in the queries that our members run. In a case where millions of individuals are screened just for private sector jobs over the course of a year, particularly in jurisdictions that are near high volume hiring areas, such as areas that may be right now ramping up for holiday season hiring, and right in the middle of that. Some of those courts, some of those departments of corrections, some of those police departments aren't always configured to handle the scale that comes with normal seasonality and a return in the economy. So the degree to which the private sector through CDIA and PBSA can be engaged early in the process of access technology planning, we think we can better inform our members about coming changes, but also I think inform the court's planning process about the identifiers, the scale, and the confidentiality and data security that our members offer in the use of the identifiers that we need in order to run our businesses. So let's looking ahead. How do we better use the expertise that Jose's organization and mine represent? 3 simple solutions. First of all, engage in the private sector early to evaluate the screening use case and look at models that work from other jurisdictions, other states around the country. Invite the industry to participate in the planning process to make sure that the constraints, whether they're policy privacy constraints from the Supreme Court or from the state legislature, are properly addressed. But at the same time, the appropriate volume and scale that the industry in that state has for background screening is accommodated in a way that's scalable and minimizes the demand on court clerks. We know from our experience there are better ways to do this that can drive efficiency and accuracy. We think one of those ways, consistent with the CCJ COSCA guidelines, is to enable more remote verification at scale for qualified users. As we've seen from COVID, the manual clerk confirmation, slow turnaround times, obviously increase the kind of exposure that we're all trying to avoid now in a COVID environment. The degree to which we can automate the return of key personal identifying information and case details through a qualified user model, by automating this process, we can address these questions at scale and reduce burdens on court clerks, as well as face-to-face access. And then finally, the PASS technical standard I mentioned. It's a good tool to use as you look to formats and exchange call and response formats for future technology upgrades. So that's a little bit about us and where we're coming for. We'd be happy to dive into the PASS document some more, but I think I've talked long enough. I'd be happy, and Jose, I know, would be happy to address any questions that there are after we get a little public service announcement here about upcoming NACM events. So, Mr. Carter, can I throw it over to you?
Yes, let's go back to your contact information first before I do the announcements. Let's just get any questions that some individuals have asked about your presentation.
And we do actually have a few questions. First question that came in was, is this software or web-based?
Jeff, are you there? We cannot hear you.
Yeah, I'm talking. Can you hear me now?
A little bit, a little faint.
Sorry, I was trying my connection there. The first one that came through is this software or web-based?
I can't hear you, Jeff, but I see the question, so I'm going to ask one of the questions. Yep. And that is the software, is it a software or is it web-based as relates to your product?
So we're product agnostic, so the specifications can fit with common software solutions for core public access. I think in talking to some of the providers, they've said they're capable of providing this functionality. This is not the hardest thing in the world to do, but it needs to be requested, and often it's not in the spec. So we are really, as it relates to the type of the application, this can be used in really any sort of software. It can also be used where this is a bulk download of a file to make sure we have sufficient identifiers in a bulk download to accurately identify individuals with common names.
The next question was, is the information in real time?
So question on the pass spec, it enables the call and response in real time of these queries. And right now, our ability to deliver in real time is where a court or other public record source can provide that. With sufficient identifiers, we can turn that around in near real time for a background check. Where the matching is ambiguous or the identifiers of the case information require a second step, then we'll have to run an additional query in order to turn around the result. But again, the approach of the pass document is to have as many identifiers as possible for a registered user, and in that way, speed the turnaround potentially on a real-time basis.
Great. There was the next question that was, is pass a membership or a payment per use?
So pass is free. Pass is really a document to be used regardless of what software provider you're working with as your contractor. We have used it where a court jurisdiction will ask for input from its user community about how to use resources more efficiently for public access. So we're happy to provide it for free. As you see, it's not behind a firewall. We're happy to discuss or speak to any of the specifics that are in it, but it's really designed to drive efficiency and accuracy in the call and response process for criminal history requests.
Great. We had another one that said, many of us are in the process of updating technology. Are you working with tech companies to provide best practices?
We are. So we've provided this to the contractors that are in this space, providing various tools used for court access technology. And as well, this is a consensus document from the industry that are the predominant users of criminal history information from the courts. So there is good understanding in the industry as well as with other contractors in the court access technology space.
This is Jose, and I would also add that if you are talking to one of these vendors that you mentioned, that if it reflects the past document standards, because sometimes we have issues also as well for some of the identifiers that don't appear when a state is or a court system is moving from one to another. We're looking for DOBs, we're looking for other identifiers. It's always good to mention that does it have the past standards incorporated in there.
And that actually leads us into the next question of how do you secure sensitive information?
So the members secure sensitive information with a wide range of data safeguards. Obviously the vendor contracting that we will do for any providers we have under our agreements that may be accessing this data are ones that have strong obligations that meet or exceed applicable law. We will, again, while this is public record information, We have significant obligations under the Fair Credit Reporting Act, as well as additional contract obligations that we are accustomed to under many of the credit reporting, credit bureau requirements for strong user authentication requirements, strong attestations and certifications by the user that this information is not going to be used for impermissible purposes, but only those that are authorized under the law or under the constraints of the source jurisdiction. And we monitor as well for unauthorized use. While it is public record information, we take pains to preserve preserve the confidentiality of the information and make sure there's no unauthorized access to the data.
Great, we got a couple more here for you. Next question is, what is the CCJ Casca paper that was referenced regarding criminal history information and the court database updates?
So
I don't think that.
Yeah, do you want to speak to that?
I don't think. Right, I don't think that goes into that much detail on criminal history information. I think it's I've referenced that more as a tool for court leaders and your members to take that paper when you are looking to improve remote access to the public, and just say the CCJ Casca leadership groups, the policy-making bodies, it's recommended that remote access be implemented, especially now during the pandemic. There's always been this technology solutions for providing the public with remote access, and court leaders, for whatever reasons, have never really fully embraced that. Could be because somebody does not want to do it, or of course always funding. But now this is a good policy paper for you all to rely on, to say, put that in your folder and say, well, the largest the policy leadership group of the courts is recommending that remote access be provided. The solutions are there, we just have never really implemented like we want to.
Which kind of leads us into the last question we have of, if you were in front of clerks, what would be your best advice you would give them to make access to this data better?
Well, I think that's a good question. In terms of what we communicate to clerks, obviously part of this is going to be dependent on the system and the constraints. So we know that a lot of these are state-specific or jurisdiction-specific solutions, right? But as a general matter, where we can automate for registered users access to additional identifying information, we can reduce the demand on court clerks to fulfill manual requests and speed the response for the benefit of consumers and businesses that are engaged in those searches.
Great, and that actually concludes all those that were submitted. So I do appreciate you answering all the attendees' questions today.
Thank
Well,
you,
Jeff,
for asking.
Our pleasure.
And thank you, Mr. Demas and Mr. Harris. Just have a few announcements on behalf of NACM. We can move to the next slide.
There you are.
Just want to mention that as it relates to NACM, on nacmnet.org, NACM is really proud to have a podcast, and it's a podcast that is featured every third Thursday. Our next podcast is November the 19th, and the title is Protests, Forest Fires, and the Pandemic. And you can learn so much about what these podcasts have to offer, and we would love to get an opportunity to hear from you and your experiences. You can find more information again about that on NACMnet, that's NACMNET.org. And also just want to mention to you briefly about Save the Date. NACM has its mid-year conference February the 14th through the 16th, which will be in Jacksonville, Florida. And then we have our annual conference July the 11th through the 15th, that'll be in San Diego, California. More details will be forthcoming. So please always go back and refer to our website, that's nacmnet.org. And just for those of you who may be interested in joining NACM, we have so many opportunities for those who may be interested. Just to list a few of them, we have the Court Express, which is a newsletter which contains news about the court community and information about NACOM events and members. We also have the Court Manager quarterly journals, which include numerous articles of interest to court managers. We have one-on-one opportunities for mentorships for those who may be interested in going into court or judicial administration. We also will have opportunity to discuss with other court professionals around the world to discuss emerging issues within the courts. We currently have between 1,650, maybe 1,700 individuals that are part of our great organization. You also get the opportunity to join on NACOM committees with other colleagues, as well as listen to the NACOM board members or the board of directors on what directions we're possibly going on future trends. We also have the opportunity for a discount registration for NACOM conferences if you are a NACOM member. And we especially have an opportunity for those who are interested to have conference scholarships that may be available. NACOM is such a great opportunity for those who may be interested. Please feel free to go to nacomnet.org. I hope you all be able to join us in the future. And Mr. Demas and Mr. Harris, we truly appreciate you all taking time out your busy schedule to explain what your company or companies do as it relates to the courts. Any other final words?
We thank you for the opportunity. Court clerks are an important audience for us, and we think if we can work together and improve the lines of communication even more, we can make it easier on both of us, both industries. So thanks for the opportunity today. We really, really value your time.
Thank you.
Well, thank you all. And for all those who participated, you will be receiving a survey in regards to this webinar, and we look forward to your positive feedback. You all have a superior day. Thank you all.